In Mex Group Worldwide Limited versus Ford and others, the High Court determined costs following the discontinuance of proceedings and discharge of a worldwide freezing order, obtained under Section 25 of the Civil Jurisdiction and Judgments Act, 1982. The central issue was whether the claimant, MGWL, should pay the defendant's costs under Rule 38.6, despite having proved contempt against them for failing to provide asset disclosure. The worldwide freezing order had been obtained by material non-disclosure, and other defendants had succeeded in having it discharged on that ground and for want of jurisdiction. Friedman J. held that MGWL must pay the defendant's costs as the discontinuing party, but modified the order to reflect the proven contempt. MGWL recovered only 50% of its contempt costs to 13th December 2024 on the standard basis, and nothing thereafter. Existing interim costs orders for unjustified adjournments stood, despite the discontinuance. The court refused indemnity costs, given the multi-directional nature of the costs orders. The decision demonstrates that discontinuance costs principles prevail, even where contempt is proven, particularly where the underlying injunction was wrongly obtained. Quote, "In my judgment, the circumstances of this case are different, such as to justify a modified departure from those usual circumstances. That is, to reflect the fact that it now appears the worldwide freezing order should either not have been obtained, or that it should have been withdrawn, such that the initiation and/or continuation of the committal proceedings were not justified. There should nonetheless be a modified costs order in respect of the contempt application, in order to mark the fact that Mr. Smith and CSM were in breach of the court orders in failing and refusing to provide the information." They also raised points about service which were rejected.
For a detailed summary of this decision, visit tmclegal.co.uk.